This doesn't involve the parents. This involves the individual that's attempting to procure or procuring an abortion without the knowledge of a parent. It doesn't cover the parent that takes their child out of state to have an abortion. And recruiting, harboring, and transporting, those are descriptive words. I guess the court would have to decide if the conduct constitutes one of those three things.
Well, that is exactly what the court is deciding. And the legality of Idaho's abortion trafficking law hangs on the Ninth Circuit Court of Appeals deciding if those three words, recruiting, harboring, or transporting, as you just heard Senator Todd Lakey talk about, and their connection to a minor getting an abortion in a state where it's legal, whether those words violate sections of the U.S. Constitution or their interpretation of that. Idaho's abortion trafficking law was passed in 2023, and it makes anyone who takes a pregnant girl out of state to get an abortion without her parents' consent a criminal with the possibility of 5 years in prison. It went into effect in May of 2023, and in July, the law saw its first challenge in court. An injunction was granted in November, preventing it from being enforced, and yesterday, it was before the Ninth Circuit Court judges. Andrew Bartline followed the arguments for us today, or looked into them yesterday and today, and this all balances on how the court defines that trafficking and specifically those three descriptors we mentioned.
Yeah, there's a couple pieces to it, that being arguably chief among them, whether those components of this abortion trafficking law criminalize speech or conduct being another piece of that. The state law lists off three verbs to make up what this crime is, and it comes down to recruiting, harboring, or transporting. You're looking at the law right now, and you can notice the terms. It's or, not and. The Ninth Circuit judges interpret that to mean that these actions, when they stand alone as singular, not all three, just one, could violate the law. That matters because the plaintiffs of this lawsuit are two organizations that help pregnant people get abortions. Some of those people are minors in Idaho, and legally they would need to travel out of the state to get that procedure. So at what point does the work that these organizations do cross the line and break the law? Is giving information to a minor considered recruiting? The plaintiffs say the law doesn't just ban conduct, it chills and censors their speech and violates the First Amendment.
Because it regulates only speech and expression that favors abortion. It prohibits plaintiffs from saying things that the state disagrees with. The speech intended to bring about a particular unlawful act has no social value, therefore it is unprotected. And that's precisely the problem with the statute here, Your Honor, is they're not speaking about an unlawful act. They're speaking about a lawful act, abortion that is lawful in the place where it occurs.
The judges press the state's attorney to clarify that line. Exactly when does recruiting, harboring, or transporting stand alone to break the law? The state says each step is just a cog in a larger machine, and it's the action of those steps they want to regulate, not the words.
If there is a connection between a specific minor who is unemancipated, that means under their parents' custody, and an organization that is going to harbor and transport that child to receive an abortion, then yes, that could be recruitment if it's combined with a specific intent element. But that's conduct we're talking about, not speech.
Do you need to actually have the abortion, or do you only need to make arrangements for an abortion?
The abortion has to be procured. It means that the abortion is done, the child is terminated.
So unless an abortion is actually carried out, we've learned that the law would not be violated. Further, the plaintiffs argue that the organization's work historically is an expression of supporting people who want abortions. And the conduct of doing that action, the plaintiffs say, is connected with the speech of supporting that action. The Ninth Circuit judges were pleased with the arguments, Brian. They said they appreciate it from both sides. And so we'll come back and see how that ruling works out and exactly drawing the line and if those can stand alone or if all three need to work together in conjunction. We'll see what they decide.
Yeah, they hung up a little bit on that word or, and when the state's attorney used the word and a lot, including those things, they were like, wait a second, is it and or is it or?
It's funny how they kept interrupting each other because he'd use the word and. They're like, no, the law says or.
Right.
So then, that's kind of what they were trying to figure out, spend a significant amount of time figuring out the difference.
And the constitutionality they're also trying to figure out is the 14th Amendment. Am I correct with that? This equal protection
clause. That's another
clause.
piece of that as well, yes.
All right, well, again, we'll have to wait and see how they decide on this. Thank you, Andrew.